Okay.
May I please, my lords? Lordship, I beg to mention item number 6, Lordship.
Item number 6.
Yes, Lordship.
Yeah.
Lordship, similar matter issue pertaining to this case is pending before the Honorable Supreme Court.
But the division bench has already decided writ appeal or what?
Yes, Lordship. Yes.
Division bench has reversed the judgment of the learned single judge or maintained it? What happened in similar writ appeal?
Yes, regarding ex post facto regularization of work charge service, Lordship. So it was last listed on 4/11.
Learned single judge in this case, learned single judge is directed for regularization.
Yes,
Issued a direction for regularizing the services of the respondent.
Lordship.
Okay.
Lordship.
Then what in similar appeal, what happened in that similar appeal?
No.
Any appeal was preferred?
Lordship, in the other case also, the single bench has allowed the writ petition.
Fine.
It's stated as preferred an appeal.
What happened in that appeal?
The appeal was dismissed.
Appeal was dismissed.
So against the dismissal of the appeal, the state has again preferred an appeal before the.
That is pending.
That is pending. But Lordship, the difference is, Lordship, in my case, the petitioner, he was on scale of pay.
In that.
No, in my case, in the other writ petition, the petitioner was on fixed pay. That is the only difference.
But
ultimately,
the issue is
the
ex post facto.
Appointment was casual. Though he remained in service for around 36 years or
Lordship,
28?
in my case,
This is less than 30.
29
This
years.
petition is less than 30 years.
30, less than that.
And the benchmark is for the scheme.
As per the scheme, one has to complete 30 years.
So, will you please supply us the copy of that division bench judgment in other case?
Lordship, today it's not possible.
Why?
Tomorrow.
Why today is not possible? Why? You don't have the copy of that.
Not with me, Lordship.
You provide us the number, we'll get it. What's the number of that rate appeal?
Lordship, that also I'm not certain. I have to find out.
You are for the private respondent.
Yes, Lordship.
You are for the state.
Lordship.
But try to find out, let us, we'll wait for that.
Lordship.
Try to find out the number and supply the number. We'll get the copy.
And what was the decision in of the Supreme Court in Nichevi Asumi? That was posthumous regularization.
Yes, Lordship.
That was rejected by the Supreme Court.
Yes, yes, Lordship.
There was another appeal after date. Correction was made for regularization. That was rejected. Posthumous regularization.
Yes.
For admission, item number 1.
May I please, Lordships? Lordship, I'm mentioning on behalf of my senior government advocate, Lordship. Lordship, I've been instructed that one of his relatives passed away, Lordship, and he's in bereavement. If Lordship may please to list the matter after vacation.
After vacation. What is in this? It's a simple transfer order and it was listed before us on the 30th of September also. And the same request was made and the matter was adjourned. It's a simple transfer order. And at present, the incumbent is already in Kohima or Dimapur on account of some availability of the post. And in the transfer order, what is the matter? How to, up to what extent the court can interfere? Until and unless it is violative of statutory rules or malefides, that's all. This is what the settled law.
Or else Lordship may accommodate on the next week, Lordship.
Next week, no. Either tomorrow or today. That's all.
Lordship, he is in
You get
bereavement,
it.
Lordship.
You argue the case on his behalf.
Lordship,
Prepare the
since
case by tomorrow and argue the matter.
I don't have the
Nothing
brief with
in
me,
this.
Lordship. Since the brief is not with me, Lordship. So
This is.
You furnish a copy to the State Council. This is the only appeal.
Yes, Lordship.
Furnish
Very
a copy.
limited question of law involved in this appeal. However, Lordship, my humble submission is that my learned friend who is appearing in this appeal, the government advocate, is in bereavement. So, Lordship, I don't have anything to say, but then, Lordship, it's not proven my part to argue the case in any substance.
Circulate the slip in advance. If
Lordship.
that is so, why don't you circulate the slip, adjournment slip in advance?
No, so far as I'm concerned, I'm ready, Lordship. I'm for the appellant.
You're for the appellant.
Yes, Lordship.
So what's your case ultimately?
Lordship, the only issue, the grievance of the appellant with petitioner is that the initial transfer order, which was issued in public interest, has been modified, cancelled by the grave take order without giving any reason. That's all.
Where is the, show us any law.
Yes,
which
Lordship.
says that, which says that you have to assign the.
This
reason
honorable
for the purpose
God
of
in
that.
getting up decision, Lordship, it has been held that,
Yes, show us that this.
yes, Lordship.
Yeah.
I have three decisions only, Lordship.
Show us.
That is the list of books, Lordship. I'm here to supply that one, Lordship.
You supply that. Get these. We are hearing this matter. Yes, Mr. We are hearing. You are for the government advocate, na?
Lordship, or else if this matter can come up on Monday, Lordship.
Not Monday. He's ready, then what's the problem in that?
Lordship,
We are
since
hearing it.
I don't have the brief with me, and then I've been instructed that since The leading counsel is in bereavement.
Yes. Get the copy of these judgments. Yes. Which is that order?
Lordship,
You are agreed
are
by?
we allowed to take a lordship petition to first transfer order, lordship?
Yes.
Page 20.
Page 20.
Yes.
Yes.
This order dated 10/10/2022. In the interest of public service, the governor of Nagaland is pleased to order transfer posting of the following associate professors, assistant professors under higher education department. By this order,
Your name is
my name is serial number 25.
25.
Next page.
Next page. So you transferred from this
Wangkau Government
Wangkau
College,
Government College to Dimapur Government
Development
College.
Government College, and the private respondent of lordship for that is serial number 26.
26.
Yes, she was transferred from Dimapur Government College to Wangkau Government College.
Okay, fine. Mon. Yes, then
Then lordship, within a period of 1 month, page 23A is the type copy, lordship.
page
Page 23
23. Yes.
and 23A is the type copy, lordship.
Fine.
This is order dated 9 November 2022.
Also, in the interest of public service, the government of Nagaland is to order the following associate assistant under the higher education. In 1 year. This Dimapur Government College designated.
Yes, lordship. So my name is serial number 5, lordship.
Yes, 5 is your name, na? 5 is the appellant.
Yes, lordship.
Yes.
Yes.
So,
By this order, lordship, I can transfer from Dimapur to Saujang College, Twin South. And the respondent for was written at Dimapur College.
transfer to
Initially, I was transferred to Dimapur,
Dimapur Government College.
and by this ambient order, lordship, I was transferred from Dimapur to another college again within a period of 1 month, lordship.
Which college? Another college?
Lordship,
Which another college?
to Saujang College on the right-hand side, lordship, remarks column,
Transfer to South Chang College.
Twin South.
I'm saying against Limke transfer and Kohima College. Okay, fine.
So agreed by this modification of the lordship, I approached the nursing judge
Yes.
on the ground that when a transfer order issued in public interest is modified subsequently, reason should be given for issuing such modification orders. That was the only ground I've taken before the learned single judge, because lordship knows, so far as the scope of judicial review in transfer matter is concerned, unless there is violation of rules, malafide, or the order is issued by an authority not competent,
Has no locus standard.
this honorable court has limited scope to interfere. My case was not based on that principle, lordship. My case was that the transfer order issued subsequently by modifying the initial transfer order has been done without giving any reason, without assigning any reason, which is in violation of the law laid down by the honorable court and carried up decisions. So, lordship, the learned single judge, without considering my specific case, lordship, with regard to modification, Lordship, come to a conclusion that there is no violation of rules, no malafide, which was not my case at all, Lordship. Before the learned single judge and dismissed the writ petition.
Yes.
How that conclusion arrived, Lordship, may kindly see in the impugned judgment in our Lordship. By filing an affidavit in opposition by the respondents, try to justify the.
Where is the finding of the learned single judge of this aspect, please?
Lordship, may kindly come to page 96 of the impugned judgment.
Para number? Para of the impugned judgment?
Lordship, finding page 111. Para 23. Dribble one, Lordship, page 111. Para 23, married Lordship. Upon hearing the parties, it is seen that although the second transfer order has been issued within a period of 1 month, transferring the petitioner from Dimapur Government College to Saujang College, Tuizang. However, the petitioner could not prove the issuance of the said impugned order with a malafide intention, or it was made in violation of any statutory rules. And as much as the said modification transfer order was issued in consideration of the representation submitted by the respondent number 4, and as such, no malafide intention as alleged by the petitioner is made. I never alleged malafide, Lordship. And violation of rule statutory was not my case, Lordship. My only case was the modification order was issued without any standing reason, which is in violation of the law laid on by the Honorable Court. That was my specific case, Lordship. (1997) GLD, 1 GLD, Lordship. I'm referring to 1997 1 GLD.
That's all. This is the only reason that they have not given any reason
Yes,
while
Lordship.
modifying the earlier transfer order.
Yes, Lordship.
And this court is, in these judgments have said that the reason should be supplied.
Yes, Lordship. And Lordship, the immune order, which was issued on 9/11/22, no reason has been mentioned, no reason given. However, by filing the affidavit in opposition, the respondent tried to justify the immune notification order by bringing new reason, Lordship. So that cannot be accepted in view of the principle laid down and Mohinder Singh case, Lordship, which is also reflected in the judgment reported in 2021-5 GLD, Lordship. That is also mentioned. So that was my specific case before the single judge. And the law laid down by this honorable court was not considered by the single judge and dismissed the writ petition, Lordship.
That's all.
Lordship.
Close for orders. Close for orders.
Lordship, if I may also make a short submission, Lordship. I'm representing the private respondent number 4.
So what to do?
Lordship, my contention before the Leonard's single judge was on 2 grounds, Lordship. First, because of the medical condition of the respondent number 4's son, Lordship. He was 4 years of age when the immune order was passed, Lordship. Now, the first transfer order was issued on 10/10/2022, Lordship. And after 2 days, Lordship, I have submitted a representation before the competent authority, stating my reasons, the medical conditions, Lordship. And on considering the representation submitted, Lordship, the modification note was out, Lordship, after a period of 29 days.
So what was the problem? How your son or child was suffering from what?
Down syndrome, Lordship. The government has already filed the affidavit. They have enclosed the medical documents, representation, as well as the forwarding letter. Now, on considering, the government has filed the affidavit, specific averment has been made that was not any on other grounds. It was on the condition which was submitted by the private respondent number 4. So, Lordship also knows, in order to interfere with a transfer order, there has to be mala-fide intention or violation of statutory rules. No violation as such, Lordship. Lordship also knows, I also relied upon a judgment passed by my Lord Justice Gauhati, Lordship, which is also reflected in the Leonard single judgment, Lordship. If your Lordship may kindly allow me to refer to the judgment, Lordship. If your Lordship may kindly come to page number 108.
Where is the copy of the judgment?
Lordship, it has been reproduced here, Lordship. Reproduced here in the judgment, Lordship. Paragraph 19, Lordship will find page number 107, Lordship. Page number 107.
Yes.
The last paragraph, the learned counsel for the respondent number 4 also relied upon the decision of Dharamnath Giri versus the Union of India represented by so-and-so, reported in 2021 SSC online so-and-so. The relevant paragraph number 8 and 9 are reproduced here and below. Para 8. In the case in hand, the petitioner has annexed a number of office memoranda and also of a record office instruction as have been indicated above. From the record office instruction, it transpires that if the husband and the wife are working in the same department, posting of both spouses together at the same station where required level of facilities are available is to be considered to enable them to lead to normal family life and to look after the welfare of the children, especially till the children attain 18 years of age. The office memorandum so has formulated that common employee who has disabled child, this is important, Lordship, serve as the main caregiver of such child, and thus any displacement of such common employee will have a bearing on the systematic rehabilitation of the disabled child, since the new environment setup could prove to be a hindrance for the rehabilitation process of the child. In such situation, a government servant who is also a caregiver of a disabled child may be exempted from the routine exercise of rotational transfer subject to the administrative constraints. The subsequent guidelines have also highlighted the same position. The office memorandum dated so-and-so is on the subject exemption from the routine exercise of rotational transfer. It mentions that a government employee who is a caregiver of the dependent daughter, son, parents, spouse, brother, sister with specific disability, as certified by the certifying authority as a person with benchmark, page number 5 and 6 disability is defined under section.
Okay, we'll read this.
So it's a
Okay.
lordship. This is one lordship. And the government has also enclosed the office memorandum, which I've just referred upon. Now, even the medical documents, which I have also submitted before the authority, has also been considered by the department lordship. Now, my respectful submission before this and before this, the petitioner before the legislative judge has failed to make out a case that there is violation of statutory rules or malified intention in issuing those orders, lordship. And also, the circumstances was different, lordship. My respectful submission is that it is an exceptional case where the authorities, or maybe lordship, even before this local court, should not interfere with such kind of administrative orders, because the qualification order was issued in a very exceptional circumstance.
Okay.
Lordship, one minute, lordship. The grounds and the submission made by my friend is not reflected in the ambient notification order. I'm also a mother, lordship. I'm concerned about my child. But then that is not a related case of the petition to record.
Still you are continuing in Dimapur?
Yes, both the petitioner responded.
Close for orders. Yes. Next.
For admission, item numbers 2 and 3.
Yeah, Mr. Lordships. But I'm here led by my senior Mr. A. is Gomi Lordship. He has filed a letter of absence. I've already informed the other side also. So Lordship, if the matter can come up after vacation, Lordship. In fact, Lordship, the appellants, the writ petitioners and the writ petitioner are agreed by the streamlining, bringing them to the state carer by the cabinet in an imaginary date, Lordship. They were regularly recruited through a proper advertisement.
You are ready with the case?
Lordship, I'm led by my senior, say it's more Lordship. So if Lordship may kindly go committed that this matter after vacations.
Where is Mr. Senior? Your senior advocate.
Mr. A is home, he's on leave, Lordship. He has filed a letter of absence. Because of our personal vehicles, Lordship. And next week, the matter will not be released before Justice Devashish Bora, because he's sitting next week, Lordship. Or it could have been taken up next week.
After vacation.
I'm
Yes.
deeply obliged. Deeply obliged.
For admission, item number 4.
So, Lordship, mentioning for my senior young one, all the respondents, for my senior young one.
Where is he?
He's engaged in other program, if he's sitting for a hearing in other.
Password for the time being, call him.
Yes, Lordship, meantime, but we are here to file a litigate in this case here,
You are for
for the respondents.
respondents, you first, you are for argue the matter. Argue the matter. Argue it out.
The chief, since my the leading counsel is in Bihar.
Call him. Password for the time being, call him. This armed forces traveling.
For admission, item number 5.
And for the respondents, five, Lordship.
Which matter?
For item number 5, Lordship.
Yes.
Yes, Lordship, mentioning for my senior, in this case is with, Lordship, we received an instruction only yesterday. So I pray for an adjournment for.
The state has filed reply. State has filed response. You are for respondent number 5. Who is respondent number 5? What is this? what relief he has sought against you? What relief the petitioners are seeking against you? Respondent number 5.
Union of India. Apologize, Your Lordship, but I'm not familiar about this case.
Lordship, if I may. Yes, we are seeking a clarification as to whether Ratna is equivalent to DA.
Whether?
Ratna qualification in Hindi
Yeah,
is equivalent to DA.
so
That is the
issue involved in this petition. Yes. So how you are supporting this, that Ratna is equivalent to the, this B.Ed? What is the material you have placed on record?
No, Lordship, the issue involved in this case is that we, the petitioners, we are all qualified Hindi graduates.
Fine.
Now, advertisement was issued on March 16th, 2022 for graduate Hindi teachers. Now we as qualified Hindi graduates, we also applied for the post, graduate post. However, our applications understand that we're not qualified,
Yeah,
and that's why we are challenging.
the validity of that.
Yes, yes.
Particular
this
rule.
Yes.
Yes.
So,
So your challenge is based on what grounds?
on the ground that Lordship, we are also qualified Hindi graduates.
So what is the material in support of your contention that you are qualified and the state government is legally not recognizing this?
Lordship, a document dated 5th May 1988 was issued by the Ministry of Human Resource Development, Department of Education, Shastra Bhavan, New Delhi.
Fine. Where is that?
Lordship, it's at page 141.
141.
Yes, of the repetition. Now, Lordship, page 141.
The selections are already over. Pursuant to the advertisement, the selections are already over.
Yes.
Yeah, that's in pursuant to that order, the selections are already over. So now this writ petition is pending only regarding this validity.
Yes, Lordship. Yes, Lordship.
Will grant you liberty as and when occasion arises, you can raise this. Why to keep this matter pending? Because substantially you are not getting any, they are not going to get any relief.
Yes, Lordship, but this petition will also decide the future of, many Hindi students who are pursuing studies.
That's why only we are granting you liberty. Whenever any advertisement is issued, you can very well challenge that again. If
That will be
it
a,
requires so.
that will be a long process again, Your Lordship.
You collect the materials in the meantime from the government of India that your qualification is equivalent
Let them,
to
Lordship,
as a graduation in Hindi.
since studies pending, Lordship, let the union bring the document.
Having heard the learned concept for the parties. We are of the view that matter requires consideration, hence admit. Since the respondents are represented through the council, no need to issue notice, no need to issue formal notice, just in due course. In the meantime, the Union of India may also file their response.
For admission, item number 4.
Yes, item number 4.
Yes, Lord.
Call your senior. Go and call him.
Yes.
Go and call.
For hearing, item number 6.
Got the judgment.
Yes.
I wonder that the case pending in the Supreme Court will have a bearing on this case, Lordship.
What is the bearing in that? In that case, the employee has already completed the 35 years. And here in your case, it's less than 30 years.
Twenty-nine years, 4 months, 3 months. 29 years, 4 months.
Less than 30 years.
Less than 30.
Then
Should be here in the judgment passed by the single page. Should be kindly see para 5, page 78.
yes,
Yes, proceed. Should the difference between the person guessing the case which is pending before the Supreme Court is, proceed here the lead petitioner, he wasn't he wasn't fixed P,
he was a
fixed P.
fixed pay. Okay.
Whereas in my case, the petitioner, he was on a scale of P.
Oh, whatever it may be, what is this provision for regularization? Is
So,
there any difference between
Yeah,
the
for
fixed pay regular?
yeah, so as per the scheme framed by the state government,
Yes,
an employee has to complete 30 years of service in his, and one has to be on a scale of.
Fine.
That is the condition which is prescribed in the law.
fine.
Worship, as I've released from service before completion of 30 years. That means after serving for 29 years, 4 months.
Fine.
So in the writ petition, my prayer was
Mhm.
the period of 7 months something, worship. That may be considered on a humanitarian ground.
What is
And
what is the authority with the court to pass such order in violation of the policy? Then why not a person, even if he has completed 25 years of service on humanitarian ground, he may also ask that waive this period of 5 years. What is the criteria for that, sir? That 7 months we can can be waived, but not a period of 5 years.
yes, worship.
Because maybe he may also have some more humanitarian ground than you have. A person who has only completed 25 years of service,
Yes, worship.
he may also say that I have also humanitarian grounds, kindly waive this 5 years period or that.
Worship,
There must be some criteria for that.
worship, that was a scheme of 2015.
Yeah.
Prior to the scheme of 2015, there was a scheme of 2004.
Yeah.
Worship, the learner single judge, while passing the immune judgment, has taken into consideration the scheme of 2004.
Was in that 2004.
In the 2004 scheme, the purpose was 50% of the vacancy, total vacancy arising in a year. That has to be, in that 50%, the work charge employee has to be regularized. In the remaining has to be on by direct recruitment.
Fine.
Worship. In that 2004 scheme, no length of service has been prescribed. Worship.
Fine.
So, worship, the learner single judge has taken into consideration the scheme of 2004 and also worship that is reported in para 5, page 78.
Read.
Page 78, worship, para 5.
Page 78, para 5. Yeah.
Para 5 in the immune judgment. Worship.
Yes.
On careful perusal of the direction given by the learner single judge in judgment suit, the operative portion of which has been already reproduced here below. Worship, this was a second round of litigation. In the first round of litigation in my case, this honorable court has directed the state respondent to consider my case under the 2004 and 15 scheme.
But
But they have not taken into consideration the 2004 scheme, and they have considered my case only in the 2015 scheme, saying that since I've not completed 15 or 25, 30 years, I
But
cannot be
if that
considered.
scheme was not in existence at that time when the direction were issued by the learned single judge.
2015, no, Your Lordship, the 15 scheme was also in existence. Your Lordship, the first read petition was disposed of on 37, 2019. After the 2015 scheme came into force, Your Lordship.
This is not expressly said. In the 2015 way.
Your Lordship, the first judgment passes in page 52 in the memo of appeal. Your Lordship, the first judgment is at page 52.
Where is the 2004 scheme?
Yes, Your Lordship. It should become the page number 55.
The direction was issued for consideration of your this in 2019 did petition when this direction was issued?
Your Lordship, that is in page 52.
Page
52.
52.
Direction was in page 75.
Page 75.
Should operative portion at page 54. Your Lordship.
Extra.
Yeah, page 54.
Is 75. The judgment is
In 2019 judgment.
2008.
Page 54, Your Lordship, the operative portion.
You are for the
I'm for state, Your Lordship.
state, how this two schemes can run parallelly?
Lordship,
2004 and 2015?
Lordship, it appears like 2004 scheme was not adequate enough to absorb large.
But in 2015 scheme, you have not, there is no such mention that it is in
Continuation, Your Lordship.
continue or it is in supersession of the earlier scheme.
That is there,
So
Lordship.
how the both the schemes can run at the same time?
Lordship, in that case, in 2004 OEM, a person, we do not consider on the length of service, but we consider on the basis of seniority and merit. But for 2015, a person should have enjoying scale of pay and he should have completed 30 years.
The sports direction was to consider his case for regularization in view of the policy of 2004 as well as 2015.
For senior
Both.
minister. That could not be, Your Lordship.
That could not be the issue.
Yes.
Challenge that.
So we have, the state is not in appeal here, Your
No,
Lordship.
Lordship, that the order was
state is
not
independent.
that order was not challenged.
Which one?
Lordship, even otherwise, even under 2000, even if
the petitioner in the writ petition is to be,
Just tell us whether he was entitled for regularization under the policy of 2004 or not.
Lordship, at the time, the seniority, the one basis is
So
seniority.
even though if his case was considered at the time in 2004 policy,
Yes.
whether he can be considered for regularization or not.
No, Lordship, because he
What
was
is that?
last page. If you look at last page of the memo, Lordship, the seniority list I've enclosed,
Memo of,
the appeal, Lordship.
yes,
Even in 2015 and 2016,
yes.
that is only pertaining to her divisions. There are so many divisions. Even under her own divisions alone, she is not the senior most, Lordship. So talking of 2004, Lordship, she's nowhere. She will be nowhere because the scheme mandates, 2004 scheme mandates seniority come merit. The petitioner, the writ petitioner is serial number 2, Lordship.
Mr. Advocate General. Mr. Advocate General. What is this confusion about? There were earlier the policy and scheme for regularization of service of work charge employees is 29th of September 2004. Where you said this clause 4 specifically says that the work charge employee will have a right to be considered for
Page 81.
regularization against 50% of all the future vacancies of similar nature in the department for which they possess the requisite. Such regularization will be considered on the basis of seniority cum merit. This means that the senior most work charge employee in the relevant category will be regularized subject to her fitness in the vacant post. Then in 2015, another policy came where you said that the person, work charge employee or casual employee who has completed 30 years, his services will be regularized irrespective of seniority or whatever it may. So, both the schemes are running parallel.
In fact, though I have not gone into this brief, but I remember a similar matter which had come before the learned single judge. I think it was just about 2 months or 3 months back. I think it came before Honorable Justice Barua. I had appeared in the matter, speaking from memory, my lord. There I had clearly explained in that particular case, because the same question arose, whether both would apply or whether it would not apply. And even an order has been passed in that.
What order?
I'm offhand not able to. The order is here. I'm sorry, my lord. About 2 months or 2.5 months back it was passed.
You're recording the existing scheme. In the new scheme.
What happened in this case now?
My lord,
What happened in that resolution?
in fact, relief was, I mean, declined to some of them by one of the judgments which is here. Certain others were kept open.
75/2020, the learned single judge is ordered for listing it on 25th of July 2024 as pattern. What happened in that case?
That I don't think it has come up to my knowledge. I can find out. It has come.
Is pending.
But to give all these things, you can't keep it inside. What does this order say? I think there is another judgment of 2024. Maybe that is what, and but he inadvertently gave me 2022. A follow-up of what your lordship had said. We'll just place that for your lordship's consideration. We have it on the form.
Where the
Yeah.
order 2004 and 2015 were put to challenge. Yes. So your lordship, the judgment dated 22/8/24. In
They've
22/8.
dismissed it. They've dismissed the petition.
Pass in WPC number 204 of 2023.
24, this is the judgment only.
28.
22nd of October, August 2024.
Yes, lordship, yes.
This is the
That's
judgment
Lordship.
of learned single judge or division bench?
Single judge, your lordship.
This is the judgment.
Okay, lordship, my apology.
What is the Supreme Court judgment regarding regularization?
Yes.
Nishevi Asumi?
Lordship Nishifi Asumi that there is in case of a posthumous declaration
Posthumous regulation. After the date,
after death. Lordship.
whether that man completed 30 years.
No, Lordship. Lordship that Nishivi Asumi that was dismissed by the Supreme Court on the ground of the daily as well as on the ground that during his life service. He has not
Here
claimed.
are rejections. When the rejection,
Worship,
this, your application
yes,
for
Lordship.
regularization has been rejected by which order?
Yes, Lordship. Worship, we come to, page number 62.
62. Yes. Yes, this is the person who doesn't.
So, Your Lordship, if we see the scheme of the 2015,
Yes.
the scheme of 2004, it was made to continue for 4 years.
Which one?
Worship-
2015 scheme.
Yes, Worship. Worship, to page 57, this is a scheme of 2015. And if we see clause 1, subclause 3, that is at page number 58, subclause 3.
Yes.
Worship, got it. The existing scheme for regularization of work charge employees against normal vacancies is being modified. In the quota for work charge employees stands enhanced from 50 to 67 for the next 5 years. Effective from 1/1/2015. This existing scheme will also be applicable for the casual employees appointed on full-time basis.
So,
So after the 2015 scheme came into force also, should the earlier existing scheme, that was only the 2004 scheme, that was made to continue for 5 years. Worship.
no, it's not.
Worship.
No. They were simply saying that this enhancement of 50 to 67 will remain up to 5 years and then again it will come back to 50%.
50%.
That doesn't
Worship,
make-
after the 2015 came into force, Worship petitioner, he was released from service on 2017. 17.
2017.
Worship.
At that time, you were the senior most?
Worship, I was not the senior most, Worship, but kindly consider the findings of the learner single judge. That is reported page number, para 5, page 78 in the ambient judgment.
Page?
Page 78, para 5. Worship, this is my only grounds. Worship.
Yeah, read.
On careful perusal of the, Worship, got it?
Yeah.
On perusal of the direction given by the learner single judge in WBC number 2, so Worship, that is earlier repetition. The operative portion of which has been already reproduced here and above. It can easily be made out that the direction to consider the representative of the petitioner in terms of the office memorandum dated 22/9/2004 and 17/3/2015 was given consciously because the petitioner was in service in 2004, having been appointed in 1987 and still continuing in service. This is very important. In 2004, the petitioner had completed 16 years, 10 months. And she was very much eligible to be considered as per the office memorandum dated 2004, where no qualifying length of service was prescribed.
Consideration is altogether different thing, whether
yes,
she
Your
was
Worship.
entitled for
Your Worship,
appointment
Your Worship.
or regularization under the scheme or not.
Your Worship, in the 2004 scheme, Your Worship, this letter written by the executive engineer, Mohok Chung to the chief engineer, this letter was written only after the disposal of the rate petition in the year 2003. The compilation of regularization of work charge employees from 2004 to 17.
Fine.
Here in these documents, it shows persons who were junior to the petitioner, they were regularized. These are the huge discrimination in the department. Worship.
This is of 2023.
This letter was written in the year 2023.
Yeah.
A compilation to show the employees who were regularized from the year 2004 to 17.
Yes.
The scheme came in 2004. Lordship may come to the next page, serial number, petitioner was working as a sweeper. So in the case of sweeper, Lordship, serial number 10,
Serial number,
serial number 10,
page number,
in the next page, Lordship.
next page, grade 4, work charge employee 2004 to 17.
Yes, Lordship.
Yeah,
Serial number 10, Inna Huli.
serial number 10, yes, Inna Huli,
Date of appointment is 1999.
yes,
She was regularized in the year 2012.
2012.
Yes, Lordship. 12. A person who was appointed in the year 1999.
But the foundation before the learned single judge and the learned single judge are not allowed the writ petition only on this count that there was a discrimination. Until and unless this material was there, how can we?
Lordship, this material wasn't not available with the petitioner when the writ petition was filed.
Raise this, then we will consider this.
But Lordship, the findings of the learned single charge, Lordship, in the year 2000, petitioner has completed 16 years, 10 months.
This ground you are raising now, this case the persons who were junior to you, their services were recognized, not there in the pleadings before the learned single
Yes,
judge,
Lordship.
nor your petition is allowed on this ground.
Lordship, but the findings of the learned single
Learned
charge
Single judge findings were only this, that his case,
should have been considered in the year 2004.
but there is no finding that you were eligible for regularization in the, as per the scheme of 2004. This is not the finding.
Yes, Lordship. I agree with that, Lordship.
This is not the finding. So how 2004 may, even though, yes, your case for considering regularization was liable to be considered under this 2004 policy. But for that, we have to record a specific finding that as per that, your services are liable to be regularized. Where is that?
Lordship, at the time of filing the writ petition, if this document was with me, Lordship, that taken.
Place it on record, then we'll ask for their response.
And Lordship, one more issue is there. This is a part of the record which the state respondent have annexed in their application for Lordship.
You have to plead, then only we can
Okay,
ask.
Lordship. Yes, Lordship. Lordship, in that case, I may be allowed to file an additional affidavit.
Yes, additional affidavit raising this, this violation, Article 14 or discrimination on the part of the state. Raise this. This point was never argued, nor pleaded before the learned
Yes,
single
Lordship.
judge.
Yes, Lordship.
Otherwise, the learned single judge order is only based on this, that since you have passed, completed 29 years and so and so much, and therefore regularize their service. That can't be accepted. That can't be accepted. Legal and concept of the respondent has submitted that. As a matter of fact, some persons who were junior to, some casual laborers who were junior to the respondent, the services of some of the casual laborers who were junior to,
Work charge in place, not case.
sorry, it's, the engagement of the work charge employee of some of the work charge employee of some of the work charge employees who are junior to the respondent have been regularized, and for that he wants some time to bring those facts by way of filing an additional affidavit. How much we need?
2 weeks, Lordship.
Just after 2 weeks as per date.
Like,
If that is so, then he may be, he may have a case on the ground of this violation of Article 14 also. If that is so, if the person work charge employee junior to him, their services have been regularized, then that is the case.
Thank
Yes.
For admission, item number 4.
Yes. Yeah. Who is for the petitioner?
And for the petitioner.
Yeah, argue it.
The facts of the case is that Lordship, the petitioner, he was enrolled as Sipahi on 21/3/2005 in the Assam Regiment, which is a army regiment, Lordship, and served with dedication for 10 years, 7 months, and 21 days, Lordship. Now he has been discharged by a discharge order which is impugned here, Lordship, on 10/11/2015, Lordship, purportedly on compassionate ground, Lordship, at his own request. But such kind of request was never met, Lordship.
This is what the case is.
Yes, Lordship, yes.
How the learner, arms tribunal has dealt with this issue?
Yes, Lordship. Now, Lordship, he had a medical condition, Lordship. Now,
fine.
yes, and when he had a medical condition, he had already qualified as per his length of service, Lordship, for disability, for receiving disability pension, Lordship. Perhaps that should have been informed to him by the superior officers, Lordship.
When you moved an application for voluntary retirement.
Yes, Lordship.
You have been explained the pros and cons of that.
Yes,
And after
Lordship.
admitting that, you said, no, I want to get this premature retirement on ground of so and so, so and so. There's enough material for that. Videography of your statement is also there. What
Yes,
remains? How you
Now,
deny that?
Lordship, that statement was made under duress, Lordship.
What is the material to
Now,
say this, that you
Lordship.
were under duress at that time?
Yes, my lord is well aware that, Lordship. I did not have a good relationship with one of my superior
So
officers.
how can
Lordship.
we know yourself? Your lordship is well aware.
No.
We were not part of that organization.
Military life is unlike civil life, Lordship, where superior officers can do so many things, Lordship, to a mere chawan, Lordship.
We are not aware of that.
Yes,
You have
Lordship.
to demonstrate before us that they are doing this and
Yes.
they have done this. We are not aware of that. It's
Yes.
a general observation. Military
Yes.
officers are doing this. You are well aware. How
Yes.
can we aware?
But
We are
Lordship-
not part of that organization.
Yes, Lordship, Lordship. But my humble prayer at this stage, Lordship, is that, Lordship, he being already qualified, Lordship, for receiving invalid pension under the army rules, service rules, Lordship, that benefit should have been extended to him. And when he was already under a medical condition, and when he was already, assuming, Lordship, he had asked for that voluntary retirement, let us assume, Lordship.
You were
Even then, Lordship,
declared in a subsequent examination fit and fine.
Shape 1.
Shape 1. Everything was there.
Lordship, let the respondents, Lordship, let them file their affidavit, Lordship. And then,
If we are not satisfied with your arguments, why should we ask them to file their response? You have to satisfy us, then only we'll ask them.
yes, Lordship. But Lordship, they may not dispute some of the questions, Lordship, which I have raised in my petition. At least on that part, Lordship, I want to be satisfied, Lordship.
Want to be satisfied.
Yes,
First
and
of
if
all,
there are disputed question
your
affects the lordship.
satisfaction doesn't matter, sir. The satisfaction of the court matters.
Yes, my lord, my lord.
So your satisfaction is nothing. You may
Yes.
or may not be satisfied.
Yes.
by anything.
But
You have to
I,
satisfy this court, sir.
yes, but I at least want to receive the affidavit, lordship, after respondent's lordship.
So if this court doesn't want this, then
Yes,
we
lordship,
are not, they are in, at present, we are not in need of any affidavit from the respondents.
then lordship, I leave it to my
It's all
lordship.
your argument that you were under duress and therefore you have.
I have stated
you've been
all the-
forced to,
Yes, I have stated all the facts, lordship, in my petition. I have made specific averments, lordship. I have made specific averments.
Yes, what do you want to say?
Lordship, even with filing my affidavit, I'll just depend on the records of the petition. If my lordship may come to page 37.
Examine.
37.
Yes,
This is the report of the medical board proceedings.
yes,
My lordship may come to page 37, the relevant portion. Last para.
yes.
In view of the above, the individual is brought before the medical board, and the recommendation is that recommended to be upgraded. So his physical condition has improved. Then this is on 7 July 2010. Then again, page 42.
Yes,
This is again 27 Jan 2005. Lordship may come to relevant portion is page 43.
yes,
1, 2, 3, 4, fifth column, 22, Lordship, para 20, clause 22.
yes,
Instructions given to the present individual by the present board. You are upgraded to Medicare Shape 1 for principal disability acute. So his condition has improved. So in spite of which, he has submitted his request for discharge. That is page 45.
yes.
He has submitted an application for discharge from the service.
Yes.
Then lordship, if my lordship may kindly come to the judgment of the Armed Forces Tribunals.
Yes,
That is page 64.
yes,
This is the order passed by the Armed Forces Tribunal.
yeah,
Yes, the relevant portion, lordship, relevant portion. I kindly come to page 17.
70.
71, lordship, sorry, 71. Page 71. Lordship, 1, 2, 3, 4, 5, 6, 7, 8, 9, 10. At line 10, lordship, it says the interview was videographed in which the applicant is seen stating the reasons for leaving the service, which tallies with the reasons stated in his voluntary discharge application. So all the proceedings was conducted under video.
Okay, close for orders.
Lordship, I have raised some issues in paragraph 13, lordship.
Paragraph 13 of.
Yes,
Fine.
yes. That may kindly be reflected, lordship, as part of my submissions and paragraph 14, lordship. Regarding lordship, otherwise, lordship, if it can be taken up tomorrow, I want to place some citations also. I was under the impression that it will not be taken up because since the agreements are not completed, lordship.
Why were you under that impression that it would
I
not
was
be taken up?
expecting, lordship,
That we are not supposed to hear those cases today listed in the today's list.
that lordship, since the agreements are not complete, lordship, I would, because earlier also they have sought time to
You have
find the,
one notion,
Yeah,
what we can do, sir?
so if my kindly will list it tomorrow so that I'll at least place some citations and then the decision. I'll leave it to
We have
my-
already heard, sir. We have already heard. Close for orders.
My complaint.